Hey, Patty.
Yes, ma'am.
It almost looked like you needed to adjust the,
Yeah, I was waiting till he got in here. So now
oh, okay.
everybody's looking at us.
Come back up a little bit. Come back up a little bit more.
Yeah, I have to wait till Jonathan stands here and sees how tall Jonathan is.
Oh, it's his fault. I see.
Yeah.
Okay.
All right.
All right. Thanks.
No, it was his show, Jason.
I heard it went
Your Honor.
really long.
We don't work.
Yes, ma'am.
Okay.
Yes, ma'am.
Mr.
Hello.
May.
Is this thing on? Test, test, test.
Yes, sir. Can you hear us?
Oh, hey, there you are. Yes. What can I do for you today?
I gotta have Mr. Mays. Well, you can stay here. We have, Jason Mays that was on the docket.
Go ahead, Mr. Abraham. Mr. Mays is on the docket. I'm with you.
And he did not have an attorney. And he filled out his affidavit of indigency, and he is indigent. And I'm going to appoint the Honorable Jonathan Manning, who's standing behind me.
Very well. All right. This is cause number CR 20-401, State versus Jason Lee Mays. Motion to revoke. Court finds Mr. Mays to be indigent. The court has appointed the Honorable Jonathan Manning to represent Mr. Mays. Mr. Manning, you want me to set this for the contested docket on May 30th to give you time to meet Mr. Mays and get discovery from the state?
Yes, Judge.
All right, court will set Mr. Mays for the contested docket on May 30th at 1:30.
Wait.
Yep. Judge, ready on Mr. Gladney?
All right, Mr. Gladney, come on up. Cause number CR 23-214. State versus Cravon Malik Gladney. Mr. Gladney, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. I need you to speak up loudly and clearly so I can hear you and so we can take down a transcript of what's being said.
Yes,
Sir, is your name Cravon Malik Gladney?
Yes, Your Honor.
And Mr. Gladney, are you a United States citizen who reads, writes, and speaks English?
Yes, Your Honor.
Have you ever been diagnosed with a mental condition?
No, Your Honor.
Are you represented today by your attorney, Mr. Manning, correct?
Yes.
And are you pleased with Mr. Manning's representation?
Yes, Your Honor.
Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, Your Honor.
And is there anything about your plea agreement and the paperwork that you signed today that you do not understand?
No, Your Honor.
Okay. Mr. Manning, do you believe your client, Mr. Gladney, to be competent?
He is, Judge.
And you've explained to him his rights as they pertain to this case?
I have.
And do you believe that he is entering into this plea agreement intentionally, knowingly, and voluntarily?
I do, Judge.
All right, Mr. Gladney, you are charged by indictment with a third-degree felony offense of delivery of a controlled substance to a minor. That third-degree felony does carry a range of punishment, which cannot be less than 2 years in prison or more than 10 years in prison, and a possible fine not to exceed $10,000. That's the range of punishment. The plea agreement in your case is that upon your plea of guilty, the state's recommending to the court that your punishment be assessed at 3 years confinement in the Texas Department of Criminal Justice, along with $290 court costs, $20 in reimbursement fees, and you would receive a total jail time credit of 224 days for the time that you've already spent in jail. Mr. Gladney, is that your understanding of the plea agreement?
Yes, Your Honor.
All right. So at this time, Mr. Gladney, how do you plead to delivery of a controlled substance to a minor?
Guilty.
And are you pleading guilty to that crime because you are in fact guilty of that crime?
Yes, Your Honor.
All right. Court does accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
Judge, I did not see a stipulation of evidence in our paperwork.
I have one. I do have one here. I can try to have one emailed out there if y'all don't have it.
Judge, let me just double check and make sure I didn't get caught up. Judge, it was stuck to some of my other paperwork. If I may have just a moment.
Yes, sir.
Judge, no objection to the stipulation of evidence.
Okay, the stipulation of evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor. Thank you very much.
Anything further from the defense?
Nothing from defense, Judge.
All right, court is going to review the stipulation of evidence. All right, court, having reviewed the evidence, finds enough evidence to convict Mr. Gladney of this offense. The court will follow the plea agreement and the recommendation of the state. The court hereby convicts Cravon Malik Gladney of the third-degree felony offense of delivery of a controlled substance to a minor. The court assesses his punishment at 3 years confinement in the Texas Department of Criminal Justice. Orders him to pay court costs of $290, reimbursement fees of $20, and the court does award Mr. Gladney 224 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Gladney, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over with Deputy Martinez to be fingerprinted. Who's next?
Judge, Brian Keith Alexander.
All right, Mr. Alexander.
Thank you, sir.
This is cause number CR 21-275 for arraignment. Go ahead, Mr. Manning.
Judge, unfortunately, I was unable to print off all the arraignments for today's docket. However, I did confirm with the DA's office and have received confirmation from them that all the discovery has been provided in all the cases that are set today. If we could pull up the the indictment just for purposes of arraignment.
Yes, sir. Stand by.
Judge, Mr. Alexander's name is spelled correctly. He understands the charge against him, pleads not guilty at this time, and requests to be set for the pretrial docket.
All right, court will enter Mr. Alexander's not guilty plea into the record. Court finds he waives the formal requirements of arraignment, the reading of the indictment. Court hereby schedules Mr. Alexander for a pretrial hearing. We'll do so on June 13th. At June 13th at 1:30. Should Mr. Alexander make bail in this case, then his hearing will be on that same date at 9 a.m.
Thank you, Judge. Sign right here. My name. Sign there. Just I should be able to come back and sit you down.
Who are you ready on next?
Judge, next, I'm ready on Mr. Daniels, Robert Daniels.
All right, this is cause number CR 2447, State versus Robert Morel Daniels for arraignment. Do you need the indictment in that case too?
Yes, Judge, I'll need them in all of them. I apologize.
Oh, no problem. Give me just a second. I'll get that for you.
Judge, his name is spelled correctly. He understands the charge against him. His plea is not guilty and he requests to be set on the pretrial docket.
All right, the court will find that Mr. Daniels has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record. Court sets this matter for pretrial hearing on June 13th at 1:30.
Next ready on Mr. Davis, George Arthur Davis.
We got some emergency vehicles passing by. I'm gonna let those go by.
Yes, Judge. Oh, Judge, this is Mr. Davis.
Yeah, I know. I'm just trying to get it.
Okay,
All right, go ahead and review, and then I'll. Somebody's got their audio up. Go ahead and review the indictment, and then I'll call the case.
okay.
Do you see the indictment?
Judge, this is the indictment for Mr. Deal.
Yeah, what's showing on my screen is George Arthur Davis II.
Okay, Judge, if you want me to, we can do Mr. Deal since his is already up there.
No, just keep Mr. Davis there.
Okay.
Does somebody have another device in the jail that's creating a sound loop? Are y'all hearing that?
No, Judge.
No, sir.
All right, give me just a second. What about now?
Yes, Judge. Okay. And Judge, just real quick, I note, it looks like they put the indicative, for George Arthur the second, George Arthur Davis II, they put that behind his middle name. I guess that would be in both the body of the indictment as well as the header. We wouldn't object to interlineation to correct that.
Is there a motion by the state?
Yes, Your Honor, at this time we move to amend as such.
All right, the court's going to grant the defendant's oral motion to amend the indictment, or grant the state's oral motion to amend the indictment to reflect the correct name of George Arthur Davis II in both the heading and the body of this indictment.
Thank you, Judge. Judge, at this time, Mr. Davis's name, with that correction, Mr. Davis's name is spelled correctly. He understands the charge against him. And he's not guilty. We request that we be given a pretrial setting in this case.
All right, the court finds that Mr. Davis has waived the formal requirements of arraignment. The court enters his plea of not guilty into the record, sets this matter for pretrial hearing on June 13th. All right, go ahead and bring Mr. Dial up. Dean Evan Dial, CR 2449.
Judge, Mr. Deal's name is spelled correctly. He understands the charge against him as well as a range of punishment in this case. He pleads not guilty to this and requests to be set on the pretrial docket.
All right, the court finds that Mr. Deal has waived the formal requirements of arraignment. The court enters his plea of not guilty into the record, sets this matter for pretrial hearing on June 13th at 1:30. Austin Tyler Dole, CR 2451.
Mr. Dole is not here at this point in time. I am ready with Mr. Huddleston.
Okay. Court calls cause numbers CR 23-136, CR 23-234, 235, State versus Michael Ray Huddleston. Go ahead, Mr. Manning.
Yes, Judge. So we are here on motion to revoke, motion to adjudicate on one case, and then we're here on docket call on two other cases. Judge, this is only our third setting on his two cases set for docket call. And while I have what I believe to be most of the discovery in this case, we've yet to receive a plea offer. We requested plea offers in this case multiple times. And so I hesitate to put it on the jury trial docket without having at least have an opportunity to consider or reject something. And so with that, we proposed from the defense's perspective, a possible resolution to this case. But I know that Mr. Hartwell is out this week, so I don't know if he was able to check that and see if that would be something that would gain traction. We would request to have an additional docket call with those considerations in mind.
Mr. Hernandez, do you have any information in your case system about the offer made by the defense and whether the state's going to accept that or reject that?
No, Your Honor, not at this time. We'd ask just additional consideration for one more docket date, and we will prioritize this and make sure we get this taken care of.
Are you available on May 16th, Mr. Manning?
Judge, if I may have just a moment. Yes, Judge, I am.
All right, court sets Mr. Huddleston for final docket call on May 16th. on his violation of bond, protective order, and stalking. And we'll carry the motion to revoke of even date. If there's no resolution on the violation of protective order and stalking, then the court is likely to have a contested hearing on the motion to revoke at a later date. So we're going to carry this to 5/16. If there's no resolution, then the court's going to set that MTR on a contested docket, and the state can move forward on that. And then the other cases can be held until they go to trial.
Yes, Judge.
Thank you very much, Your Honor.
You're welcome. Who's next, Mr. Manning?
Okay. Judge, Mr. Michael Glasco.
Do you need the indictment on Mr. Glasgow?
Yes, Judge, I was able to take a look at it, but unable to print it, when I was looking at it over lunch.
All right, give me a second, because I think there's 3 of them.
Well, Judge, I believe we'd already done, I'm looking at my notes. We'd already done arraignment on the previous 2, and we're set for, we've done arraignment on the burglary of habitation CR 23-215. I think we're just here for arraignment on 24-19 and 24-20.
Okay, give me just 1 second. There you go. Yeah. Judge, his name is spelled correctly. He understands the charge against him. His plea is of not guilty at this time and requests to be set for a pretrial setting on this case. Judge, his name is spelled correctly. He understands the charge against him. His plea is of not guilty and requests to be set on the pretrial docket on this case as well. All right, the court finds that Mr. Glasgow has waive the formal requirements of arraignment in cause number CR 2419 and CR 420. Court enters his plea of not guilty into the record on each cause, sets each matter for pretrial hearing on June 13th, and also carries cause number CR 23215. Any announcements on pretrial in that case?
No, Judge, we have reviewed the discovery in that case. But we were waiting to see what these other cases, what would come of them before we announce on that.
I mean, are there any pretrial issues? I mean, do you have all the discovery? You didn't file any contested pretrial motions, is what I'm asking.
No, not at this point, Judge.
Any objection to moving that one to docket call?
Judge, I'd ask if we just run them together. But if they're all of the same date of offense. And so I'd like to compare, make sure there's nothing that turns up in, so sometimes when we have multiple cases, they put some stuff that belongs in one case and another case. So I just like the opportunity to review all the discovery in its totality before we make that decision.
All right, court sets each case for pretrial hearing June 13th at 1:30.
Judge, ready on Mr. Austin Dole. Judge, his name is spelled correctly. He understands the charge against him. Understands the range of punishment. And at this time, pleads not guilty and request to be set on the pretrial docket.
All right, the court finds Mr. Dole has waived the formal requirements of arraignment. The court enters his plea of not guilty into the record, sets this matter for pretrial hearing on June 13th. Who's next?
We have Mr. Eubanks. Your Honor, my client understands the charge against him, range of punishment in that case. His plea is not guilty and requests to be set on the pretrial docket.
All right, the court finds that James Henry Eubanks has waived the formal requirements of arraignment. The court enters his not guilty plea into the record, sets this matter for pretrial hearing on June 13th. I do note that the top of this indictment says county court of law. Not sure why it says that, but
Yeah, Judge, and there's actually, yesterday, Mr. Eubanks was set for arraignment on another felony that was filed in the county court of law. And so I'll be anticipating, filing a motion to transfer up here, to handle both cases to run together.
okay, up here, down there, whatever y'all decide.
Yes, Judge.
And I think all of those indictments should say the 294th District Court because the county court of law doesn't have original jurisdiction on felonies. It's a docket control order that directs felonies out of grand jury from the clerk's office where to be sent. So all indictments should be in the name of the 294th District Court. Who's next, Mr. Manning?
Judge, this is Mr. Gilchrist.
All right, this is cause number CR 23-233, CR 23-213, State versus Gordon Alexander Gilchrist for pretrial. Go ahead, Mr. Manning.
Judge, at this time, we have no contested pretrial issues. We request to be set on the docket calls setting. As I've announced earlier, we are still looking for an offer on Mr. Gilchrist's cases. So
Mr. Hernandez, does the state intend to make an offer on these cases?
We do, Your Honor. My understanding is that there may be some other unindicted matters that I think we're trying to wrap up. So yes, we do intend on making an offer.
All right, Mr. Manning, do you want May 16th or June 13th?
Judge, if we could just keep the June 13th date.
All right, court sets Mr. Gilchrist for docket call June 13th at 1:30. Who's next?
Judge, next ready, I have Mr. Stephen Graves.
Stephen Ford Graves, CR 2453. You need the indictment in that case as well.
Yes, Judge. Judge, his name is spelled correctly. He understands the charge against him. At this time, his plea is not guilty and request to be set on the pretrial docket on June 13th.
All right, court finds that Mr. Stephen Ford Graves has waived the formal requirements of arraignment, enters his plea of not guilty into the record, sets this matter for docket call on June 13th.
Next, Judge, we have Mr. Keith King.
Keith Deshaun King, CR 2459.
Judge, Mr. King's name is spelled correctly. He understands the charge against him, the range of punishment. At this time, his plea is not guilty and he requests to be set on the pretrial docket.
All right, the court enters Mr. King's plea of not guilty into the record, finds that he's waived the formal requirements of arraignment. This matter is set for pretrial hearing on June 13th.
And Judge, also, I anticipate we're gonna be filing a request for bond reduction on this case based off some recent information I got. Judge, would you like to run with the June 13th date, or would you like for me to get a new date whenever I file that motion?
If you want something set sooner, file it and then just request from Ms. Abraham the available dates. And we can have it heard sooner if that's what you want.
Thank you, Judge.
Who's next?
Judge, next ready on Mr. Leonardo Rosas.
Mr. Rosas, CR 21-391.
Judge, we have no contested pretrial issues at this time. We would request to be set on the docket call. Additionally, Judge, I have not received an offer in this case or request an offer from the state.
All right, court finds that there are no pretrial hearings needed in this matter. We're getting a lot of feedback here. Hang on just a second. All right, my apologies. All right, Mr. Rosas is set for docket call on June 13th.
Judge, if we may, can we get him set a little bit sooner? This, Judge, I believe, based on my review of the case, this is a mandatory probation case. So I'd like to see if we can get some movement on it a little bit sooner rather than later.
All right, court sets Mr. Rosas for May 2nd at 1:30.
Thank you, Judge.
Who's next?
Judge, I believe I have Mr. Ross next.
Jatavian Darnell Ross.
Judge, his name is spelled correctly. He understands the charge against him. At this time, he pleads not guilty and requests to be set on the pretrial docket. Additionally, Judge, I believe I sent a plea request or a plea offer to the state to see if they would be willing to consider that. So I just ask if we could maybe have that examined before our pretrial sitting.
Any response, Mr. Hernandez?
We will do so, Your Honor. Thank you very much.
All right, the court finds that Mr. Ross has waived the formal requirements of arraignment. The court enters his plea of not guilty into the record, and the court sets this matter for pretrial hearing on June 13th.
Judge, if I may, could we possibly set him on the May 2nd date?
That only gives you 2 weeks to get discovery. That only gives you 1 week to file pretrial motions.
Yes, Judge, I know, but Mr. Ross has been in jail for quite some time. Additionally, Judge, I think this is a case we should be able to get resolved pretty quickly.
All right, court sets Mr. Ross for pretrial hearing on May 2nd. Who's next?
Judge, next I have Mr. Michael Sprous.
Michael Raymond Sprous, CR 2317 for docket call.
Yes, Judge, we're here at docket call. This is our fourth setting on the case. I've requested multiple times an offer on Mr. Sprous's case and still waiting. Judge, at this time, I think we're just gonna go ahead and have to set it for jury selection.
Mr. Hernandez, any offer being made to the defendant in this case before we set it on jury selection, understanding that the court's policy is that there will be no plea negotiating after docket call?
Your Honor, if I could just have that May 2nd date on this case as well. If it has been pending that long, we should have looked at it a while back and extended that offer to Ms. Manning. I don't have information to let me know that an offer has been extended or what that may be. So for those reasons, I think if we can get those last 2 weeks, I can get all those things clarified.
Mr. Manning?
Judge, I think that'd be acceptable.
All right, court sets Mr. Sprous for final docket call on May 2nd at 1:30.
Judge, last but not least, I have Mr. Watkins.
Michael Watkins, CR 20-201, motion to revoke.
Yes, Judge, we request to be set on the contested docket for a contested motion to revoke on this case.
Do you want the next available, which is April 30th, or do you want the May 30th date?
Judge, we can do April 30th.
All right, court sets Mr. Watkins for contested hearing on his motion to revoke on April 30th. That's a Tuesday at 1:30.
Thank you, Judge.
Mr. Abraham, is that everything that you see on your docket?
Yes, Your Honor.
Okay. All right, then I guess that concludes our criminal docket for the afternoon. The court's going to be adjourned. Ms. Abraham, before you log off, stay there. I'll be back with you in just a moment.
Okay.